somebody whose name is TNT Dynamite. Am I waiting? Let's go see who this is. See if TNT Dynamite will connect. All right, so I have somebody logged in as TNT Dynamite. What is your name? Oh, there you are. You were just here. So I'm going to change your screen name. And that is or a trammel. Okay. Okay. Miss Knowles. Oh, she's not connecting. Come on. I'm going to send a chat to Miss Knowles to disconnect. Well, oh, got it. Miss Knowles, you got it. Good job. All right. This is in the matter of the people of the state of Michigan. And ma'am, go ahead and unmute your device. Pronounce your first name for me because I want to make sure I say it right.
Abria Knowles.
Yep, that's what I thought it was. All right. I thought I remembered, but usually I write it down. Because my name, everybody mispronounces it, and I always like people to have my name right. All right, so this is in the matter of the people of the state of Michigan versus Abria Knowles, file number 23-21630FH. I have Rhonda Underwood appearing on behalf of Ms. Knowles, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for pretrial. So, Ms. Underwood, how would you like to proceed?
Your Honor, I believe there has been a plea offer in this matter. And perhaps Mr. Sneed could put that on the record, Your Honor.
Mr. Sneed?
Yeah, I'm bringing it up right now, Judge. Your Honor, the plea is that the defendant would agree to plead guilty to added count 2 on the felony information, attempted identity theft. The prosecutor will recommend a sentence of no immediate jail. The people, in exchange for the plea, will dismiss count 1, and defendant will be responsible for restitution as determined by the court.
Okay. And Ms. Knowles, how old are you?
31.
Okay. All right. So, all right, Ms. Knowles, do you understand the plea offer is plea to count 2, which is a 5-year felony and up to a $25,000 fine. The count 1 would be dismissed, as well as your habitual offender 4th offense notice. So you're looking at probation and fines and costs. So
it would be an attempt, Your Honor.
I'm sorry, an attempted under count 2. So do you wish to enter a plea to that?
Yes, but is there any way I can talk to my lawyer?
Oh, of course. So let me put you in a breakout room with Underwood. So give me 1 second. Let me get that. All right, go ahead and join that breakout room. Can I ask what your name is?
I'm Dylan Lagore.
Dylan Lagore.
You in the right place?
You're in the right place.
I'm sorry I came up late.
It's okay. You're in the right place.
Thank you for respecting me.
No, they already amended the information.
I'm with my lawyer too.
All right, you can just stop talking for a minute. They already edited it, so. Yep. I misspoke when I said edit because I didn't realize that they already added it. All right. So Miss Adams, Mr. Legore did not need to be here because arraignment was waived. Could I get a pretrial date for that? And could we serve him with a notice of hearing?
Yes.
So in the matter of the people of the state of Michigan versus Dylan James Legore, file number 24-21671 FH. Rhonda Underwood represents Mr. Legore. And Mr. Legore, your attorney waived arraignment today, okay?
Thank you.
You're welcome. And, okay, and so we are going to give you your notice of hearing for your next pretrial, okay? So you have a seat. Okay, okay. So just hang out for a minute. We'll get you a notice of hearing.
Thank you.
Miss Underwood, okay. All right, so Miss Underwood, you're back with Miss Knowles. How would you like to proceed?
I believe Ms. Knowles will take that offer. It's my understanding, Your Honor, that Ms. Knowles' probation will be, and the prosecution has no objection to that being served concurrently with her probation in Pennsylvania.
Well, there's no jail term, so it
Right.
would be.
Yeah.
Okay. So Miss Knowles, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. Mr. Knowles, you're all set. You can go, okay? Mr.
Okay.
Knowles, or I'm sorry, Mr. Legore, you're all set. You can go. All right. All right. Thank you. All right. You too. Yeah. Bye-bye. All right. So you've heard the statement of your attorney and the prosecuting attorney, Ms. Knowles. Is it your intention to plead guilty to count 2 attempted identity theft, which could carry a maximum penalty of up to 5 years in prison and or a $25,000 fine? But in this case, there's an agreement that. Why are you shaking your head, Miss Underwood?
It would be 2.5 years for the attempt, Your Honor.
So on the felony information, it says 5 years, Mr. Sneed.
We can make that change, Judge.
Is it a 2.5 or a 5 year? It'd be a 2.5.
Yes.
Okay. So the reason I think the count 1 and count 2 do not have the same title. So I thought it was a different offense. Because the count 1 is personal ID information, obtaining, possessing, or transferring, which is a 5-year felony. But I don't know what the maximum penalty for identity theft of itself is.
Yeah, Your Honor, if I could, we could skip this. I'll get that information corrected and submitted.
I don't need, I just want to, hold on. Let me check something. Identity theft. I don't know what the statute is for it and what the max, is it a max penalty of 2.5? So if that's right, I'll proceed, Mr. Sneed.
Yeah, the attempt would cut it in half.
Okay, so it would be a 2.5 year.
Correct.
Okay, all right, so Ms. Knowles, you understand the maximum penalty could be up to 2.5 years in prison and or a $5,000 fine along with restitution. Do you understand that?
Yes.
Okay, now are you satisfied with your attorney and the advice that she's given you?
I am.
All right. Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court other than no upfront jail. Is that correct, Ms. Underwood?
It is, Your Honor.
And Mr. Sneed?
Yes, Your Honor.
And Ms. Knowles, is that correct as far as you're aware?
Yes.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
I don't, Your Honor.
Okay, so Ms. Knowles, how do you wish to plead to the charge that on or about August 9th of 2022 in the Village of Britain in the County of Lenawee that you did commit the offense of attempted identity theft? Guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
You understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms.
No.
Underwood?
No,
And
Your
Mr.
Honor.
Sneed. Very good. Has your attorney promised you any particular sentence or estimated what your sentence will be in terms of fines and costs and length of probation?
No.
Is it your own choice to plead guilty?
Yes.
All right, so Ms. Knowles, let's see. So do you know a Carolyn Ann Slusher?
No.
Okay, would you agree that at some point you used her personal identification information to commit identity theft? Somebody, I don't have much details about this. Ms. Underwood or Mr. Sneed, did she, well, it wasn't a card, so could someone help me out here?
Miss Knowles, did you use her information to commit identity theft and
Yes.
purchase some phones?
Yes.
Okay.
Okay,
And
so
she did not
somehow
give
you
you
got,
permission to do that.
Say it again.
She did not give you permission to do that.
No.
Thank you, Your Honor.
and did somebody give you that information, that her name and information?
Meaning?
How did you get her name and identifying information to use it?
It was given to me.
Okay, all right. Okay, are you satisfied, Mr. Sneed?
I am, Your Honor. Thank you.
All right. Well, has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has, Your Honor.
Mr. Sneed?
Yes, it has, Your Honor.
Accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights, and she does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I am going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set sentencing on February 23rd at 8:15 in the morning. Ms. Knowles, you do have the right to be present in person for sentencing, or you can appear via Zoom. Since there's no upfront jail, you can appear via Zoom if you'd like. How would you like to appear for sentencing?
Via Zoom, and you said what's that date so I can write it down again?
Yeah, February 23rd at 8:15 in the morning.
Okay,
Now, Ms. Knowles, I am going to put you in a breakout room with someone from our probation department. So even though you're appearing via Zoom for sentencing, you may be required to come in person at least one time to meet with our probation department. Do you understand?
yes,
Okay, so when you meet with the probation department, be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We'll provide that to Miss Underwood. And then reach out to Miss Underwood about a week before sentencing and she'll review that with you, okay?
okay,
All right, so I'm going to open a breakout room, as I said. And I'm going to pop you and Sarah Teskey into that breakout room. When you're done speaking with Miss Teskey, you can go ahead and disconnect, okay?
okay, thank you, Your Honor.
You're welcome, and I'll see you back for sentencing.
Okay,
Miss Underwood, I might have one more. I have someone who called in on a telephone. Can I ask your name, please? I have someone on a telephone. Could I ask your name, please?
Yes, this is Tora Trammell.
Oh, okay, I got you on a couple devices. Okay, that's fine. I'm gonna put you in the waiting room. I still don't have Mr. Malaro, okay?
Okay, perfect.
Thank you. All right, so Miss Underwood, let's double check you. I think I am done with,
What about
You.
Caleb Daniels?
yeah, he didn't show up. He did not show up.
Okay,
So I issued a bench warrant. He needs to show up so he doesn't get kicked out of drug court. So, all
thank you, Your Honor.
right, thank you. And I'm just waiting now for Sam Malaro and
If I
John.
see him in Judge Oldsabers, I'll send him down.
All right, thank you. Yeah. Mr. Malaro, good morning. So, Mr. Malaro, I have Ms. Trammell. Ms. Trammell, can you hear? All right, Ms. Trammell, this is in the matter of the people of the state of Michigan versus Tora Nicole Trammell, file number 23-21467FH. I have Salvatore Malaro appearing on behalf of Ms. Trammell, and I have Alexander Bayonetto appearing on behalf of the people. So Ms. Trammell, you might want to pull over.
Yeah, I'm at my destination now.
Okay, all right. So Mr. Malaro, how would you like to proceed today on behalf of Ms. Trammell?
Judge, can I do a breakout with her real quick?
Of course. So I'm going to open up a breakout room, and
Okay.
Ms. Trammell is on like a couple devices. So let me get there. So I'm going to assign all of her devices plus Mr. Malaro to that breakout room, and Ms. Trammell, go ahead and join it. Murphy. Hi, this is Anna Marie Ann Simone. I am ready for Jeffrey Moody and John Madison.
All righty, we're gonna go.
Awesome, and I have jail window 1 open. Thank you.
All right, yeah.
Bye-bye. The matter of the people of the state of Michigan versus Chad Eli, file number 23-21627FH. That was adjourned prior to this morning at 8, so I don't have a date for that. It'll be scheduled one. Mr. Murphy, all your people are in jail, and I did contact the jail to let them know.
Thank you, Your Honor.
You're welcome. All right, who do I have from the jail?
Jeffrey Moody.
All right, Mr. Moody, let me grab your file. This is in the matter of the people of the state of Michigan versus Jeffrey William Moody, file number 22-21055FH, 23-21623FH, and 23-21624FH. I have Isaac Sneed appearing on behalf of the people, and I have Matthew Murphy appearing on behalf of Mr. Moody. This is the date and time set for pretrial. So, Mr. Murphy, how would you like to proceed today?
Your Honor, would I be able to have a breakout with Mr. Sneed? Because I'm not sure where the prosecution position is on Mr. Moody's case.
Do you just need the plea offer made on the record?
Yeah, if I could have the plea offer made on the record and I could talk to Mr. Moody briefly, I guess.
All right, so Mr. Sneed, if you could give me the plea offer on each file.
In file ending 23FH, it's as charged. And I'm checking in file 24FH to see whether or not there's a plea offer yet. I don't see an offer in that file as of yet. Mr. Fleming has that case at the moment.
All right, so Mr. Murphy, it looks like you're probably going to need to meet with Mr. Fleming. So I can set this out about a couple weeks and give you a chance to meet with Mr. Fleming.
If we could, please, Your Honor, and I don't know, would Your Honor be able to put me in a breakout with Mr. Moody if you had time? Or
Yep.
I don't know if the
So
court's
I'm going to
back up.
set this out to February 7 at 8:30 on each file. And Mr. Murphy, if you can do the stipend order to adjourn on each of these files. Mr. Moody, Mr. Murphy is going to reach out to one of the prosecutors on your other files. If Mr. Murphy gets the plea offer and brings it to you and you decide to avail yourself of that plea bargain, Mr. Murphy will get you in sooner than that, okay? Okay, all right, so I'm going to put Mr. Moody and Mr. Murphy into a breakout room, so hold on.
Thank you.
Yep, not a problem. I only have one more person at the jail and it's your client, so. And now I have Mr. Glazier. So Matt Murphy and the jail, use the mouse and click on join the breakout room. And then Mr. Moody, when you're done, tell them I'll take, he's gone. All right, Mr. Malaro, we are back with Ms. Trammell. So how would you like to proceed on Ms. Trammell?
Your Honor, I'm going to ask to adjourn this out perhaps 2 weeks. Ms. Trammell recently completed probation in Jackson. And I'd like to sit down with the prosecutor and see if some type of plea arrangement can be made. The matter in Jackson, I think, was for the same offense, and she successfully completed it. So I think we can resolve this in some fashion.
My next available pretrial is February 7th at 8:30 in the morning. So Ms. Trammell, I'm going to set this over to February 7 at 8:30 in the morning. Mr. Malaro can do the stipend order to adjourn, and Mr. Sneed, can you sign your name with permission?
Yes, Judge.
All right, and then Mr. Malaro, if you reach resolution, you want to bring her in a different day than a Wednesday, that would be great too. Thank you, Mr. Malaro.
Thank you, Your Honor.
All right, Ms.
Thank you,
Trammell,
Your
you can disconnect, and I believe that's all I have with you, Mr. Malaro.
I think it is. Thank you.
All right,
Judge.
thank you.
Okay,
All right.
Your Honor.
Yes, thank you. All right, Mr. Let's see here. Okay, so Mr. Murphy's still in a breakout room. All right, Mr. Glazier, I have. Let's see. Murphy. And is he in, okay, So this is in the matter of the people of the state of Michigan versus Timothy John Murphy, file number 23-21364FH. I have John Glazier appearing on behalf of Mr. Murphy, and I have Isaac Sneed appearing on behalf of the people. I have a November 28, 2023 letter from the Center of Forensic stating that a notice was mailed out to Mr. Glazier and myself with a notice of his appointment for December 20th of 2023 that states that the center does not provide direct notice to the defendant. It provides it to the defense counsel, and defense counsel must provide it to the defendant. And then I have a letter dating December 26th of 2023 that the defendant failed to appear for his forensic evaluation appointment, and Mr. Murphy was given notice. Let's see, we had a stipend order to adjourn to today's date. Mr. Murphy is not here, so Mr. Glazier.
Yes, Your Honor.
He didn't appear for the forensic appointment nor today.
Your Honor, I can't tell you why. We were aware that the forensic does not send notice directly to the person, and I checked with Leo, and we did send Mr. Murphy. In fact, Mr. Murphy had called in 2 or 3 times.
Hold on, Mr. Glazier, hold on one second. Mr. Moody, you are all set. Will you let the jail know that I'd like to see Mr. Madison next?
Thank you.
Thank you, Mr. Moody. All right, go ahead. I'm sorry, Mr. Glazier.
Yeah, Mr. Murphy had come in, I think, to see me twice. My last note is he scheduled an appointment for Friday, the October 16th, but he rescheduled it, and I haven't heard from him since. He does have significant, I mean significant problems, mental health issues. But I don't know where he's at, Your Honor. He was waiting for that notice, and I don't know why he didn't show up. And I can't tell you why he's not here.
Okay. Well, I'm going to issue a bench warrant for his arrest. I'm going to set bond in the amount of $25,000 cash. And if you hear from him and you want to bring him in, let me know, Mr. Glazier.
Yeah, well, we'll see if he shows up in my office, Your Honor. Thank you.
And Mr. Glazier, I do believe that is all that I have with you. So thank you, Mr. Glazier.
All right, thank you, Your Honor.
And Mr. Madison. This is in the matter of the state of Michigan versus John Carl Lorenzo Madison, file number 23-21479FH, 23-21575FH, 23-21625FH. I have Matthew Murphy appearing on behalf of Mr. Madison. This is date time set for pretrial on this matter. Mr. Murphy, how would you like to proceed today? Oh,
Your
and
Honor,
on behalf of the people, I'm sorry.
Your Honor, we had appeared briefly last week on this case. There was a Cobb's conference in which the result was that Your Honor would agree that if Mr. Madison pleads to there was a possession with a second drug offense notice, and there's which would be an 8-year felony, and then an RNO, a 2-year felony as charged, no habituals on that the sentence would be capped at 10 months in jail, if I'm not mistaken about that. Now, I had spoken to Mr. Madison. I didn't know if he wanted to speak with me again before we proceeded. There hasn't been any change to that. That is, again, the court's cobbing to 10 months in jail, but that's not the ending of it. There could be probation after that. So again, I didn't know if Mr. Madison wanted to speak with me again before we proceed, or if he wanted to proceed with the plea.
So my notes say on file number 23-21479FH, that charge and that file would be nully pressed. On file number 23-21575FH, the plea would be to plead as charged count 1, possession, and then on file number 23-21625FH, he would plead guilty to count 1, and I'm sorry, in the prior file, there would be 1 drug sub, so and then on 625, he would plead to count 1 and 2, police officer assaulting, resisting, obstructing. The sentences would run concurrent with no more than up to 10 months in jail with whatever terms of probation and fines and costs. Is that, Mr. Sneed, the correct recitation of the plea as far as you're aware?
Yes, it is. Thank you.
All right. So, Mr. Madison, do you need to speak with your attorney?
Can I speak with Ms. Murphy?
All right, and you're gonna need to scoot up a little bit. You're kind of far back and it doesn't carry very well. It's okay, it's not your fault, it's the room's fault. So I'm going to open up the breakout room here in just 1 second. All right, go ahead and join that.
Ma'am.
Now I got Aaron Schizler. The shizzle, all right. Aaron Schizler. Mr. Schizler, could you unmute your device, please?
Yes, Your Honor, I'm trying to figure that out.
Okay, have you talked to your attorney?
Just a little bit ago, Your Honor.
Is he gonna log in?
Yes, Your Honor, he should be logged in.
He's not. All right, he is not. There he is. All right, perfect. I was getting worried. The hearing was at 8:30, so. All right, this is in the matter of the people of the state of Michigan versus Aaron Eugene Schizler, file number 2022-20739FH. I have attorney Bruce Leach appearing on behalf of Mr. Schizler, P 75056F for his P number, and then I have Isaac Sneed appearing on behalf of the people. This is the date and time scheduled for a final pretrial. We are set for trial on January 23rd of 2024, and today was the deadline is passed for jury instructions and voir dire questions. Have those both been filed by January 3rd? Mr. Leach?
I have not filed any jury instructions, Your Honor. That's the prosecution has not provided me with any jury instructions.
Well, you're supposed to provide yours and then they provide theirs.
In my experience, Your Honor, the prosecution always provides, and then if there's anything added, we would discuss potential jury instructions. But no, I notified him that we are intending on proceeding with self-defense. I just spoke with Mr. Fleming this morning.
So, Mr. Leach, hold on a second. You received a copy of a scheduling order that says no later than 1 week before the final pretrial, the parties shall submit directly to chambers a single set of stipulated instructions in a verdict form related to the specific charges and defenses. So I don't have those.
I don't have them from the prosecutor either, Your Honor. I apologize.
Well, they don't have them from you either. So we're both supposed to get together and do that. So
I had reached out.
I'm sorry.
I had reached out to Mr. Fleming several times to discuss this case, whether we were actually going to proceed to trial or whether we were going to be able to resolve it. He had not responded to me until this morning. I just called him and he said he's going to call me back in a few minutes prior to this pretrial, but he has not. So
I'm going to put you and Mr. Sneed into a breakout room while I proceed on a different case. So, let's see. And I have Alexander Bayonetto in cover. So I'm going to close these breakout rooms and delete that breakout room. Mr. Sneed and Mr. Leach. And the pretrial was at 8:30 this morning, by the way. I'm gonna open those rooms.
Thank you.
Thank you. All right, so Mr. Schindler, just hang out for a moment. All right,
Yes,
so
Your Honor.
Mr. Murphy, we are back with Mr. Madison. Mr. Madison, have you had enough time to speak to your attorney?
Yes, I did, Ms. Andrew.
All right, and I'm gonna need you to scoot up a little bit. That room just has bad audio. It has nothing to do with you. I'm sorry. So,
Can you hear me?
Mr. Murphy, yeah, it's a little bit better. So, Mr. Murphy, how would you like to proceed? Mr. Madison, are you going to plead?
Your Honor, Mr. Madison wants to plead today. The only issue he wanted to raise, which was something that I had thought about as well, was that is our understanding. I thought from after the Cobb's conference that it was one count of R&O, not two counts of R&O. But I think either way, Mr. Madison would enter a plea of guilty today to either one or two. But I wanted to place on the record. I thought it was one. And discussing with him at the jail, we had discussed, I think, just one count. But if it's two counts, then
Hold on. Who's your prosecutor, right? Mr. Bandetto, are you on this one?
That's mine, Your Honor, yes.
So is it one or two?
It was two.
Yeah, my note, my little post-it, when I met with you, see here, this says count one and count two.
okay. So I apologize, Mr. Madison. I was incorrect on that.
All right.
So he does wish to enter the plea of guilty today, though, to what was placed on the record.
They would all write concurrent, Mr. Madison, so.
Yes, ma'am.
All right, so Mr. Madison, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
So, Mr. Madison, I placed the plea offer on the record, and is it your intent? Oh, you can put your hand down.
Okay. Sorry.
Are you satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yes, ma'am.
All right, and you understand the plea offer is on file number 23-21479. That file will be dismissed by the prosecutor at the time of sentencing. On 23-21575FH, you'll be pleading guilty to count one with a drug sub, but the habitual offender would be dismissed. Do you understand that?
Yes, ma'am.
And even if there's prison guidelines, there will be no more than 10 months in jail and probation and no prison term. Do you understand that?
Yes, ma'am.
And then on file number 23-21625FH, you're going to plead guilty to count 1 and 2. The other 2 counts, along with your habitual offender notice, will be dismissed as well. Do you understand that?
Yes, ma'am.
And is it your intention then to plead guilty to those counts?
Yes, ma'am.
Now, other than the Cobb's agreement with the court that you would do no more than 10 months in Lenawee County Jail, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with this court. Is that correct, Mr. Murphy?
Yes, Your Honor.
And Mr. Bandetto?
Yes, Your Honor.
And is that correct as far as you're aware, Mr. Madison?
Yes, ma'am.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. I'm sorry. You have the right to be present at trial, to have witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your pleas are accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, so Mr. Madison, we're going to start on file number 20. Nope, this one's going to get set aside. All right, 23-21575FH. How do you wish to plead to the charge count 1, controlled substance, possession of fentanyl less than 25 grams with a second offense drug notice? Guilty or not guilty?
Guilty.
Okay. And then on file number 23-21625FH, how do you wish to plead to count 1, police officer assaulting, resisting, and obstructing? Guilty or not guilty?
Guilty.
Count 2, police officer assaulting, resisting, and obstructing? Guilty or not guilty?
Guilty.
Okay. Has anyone made any promises or threats to you to induce you to plead guilty to these charges other than what we placed on the record, Mr. Madison?
No, ma'am.
You understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Murphy,
No, Your Honor.
Mr. Madison, or Mr. Bayonetto?
No, Your Honor.
All right, Mr. Madison, other than the no more than 10 months in jail, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
All right, so Mr. Madison, we're going to start on file number 23-21575FH. So Mr. Madison, on September 25 of 2023, were you in the city of Adrian in the county of Lenawee?
Yes, ma'am.
And did you have in your possession fentanyl?
Yes, ma'am.
Did you know it was fentanyl?
I thought it was regular heroin. I did not know it was fentanyl.
Okay, so you thought it was heroin, but it turned out to be fentanyl.
Yes, ma'am.
But either way, you had no legal right to possess either of those.
Yes, ma'am.
Do you know you're lucky to be even sitting here and talking to me today after using that?
Yes, ma'am.
Okay. And would you agree it was less than 25 grams?
Yes, Your Honor.
Now, Mr. Madison, you have a prior conviction of possession less than 25 grams from April 3rd of 2013. Is that correct?
Yes, ma'am.
Okay. Are you satisfied on that file, Mr. Bayonetto?
Yes, Your Honor.
Okay. Now let's move on to file number 23-21625FH. So Mr. Madison, on November 10th of 2023, were you in the city of Adrian in the county of Lenawee?
Yes, I was.
And at that time, you came in contact with some Adrian police officers. Is that correct?
Yes, ma'am.
So were you driving down the road? Were you in a car? Were you walking?
I was sitting in the car.
You were sitting in a car. And so did you get pulled over, or were you just sitting somewhere in your car?
No, we was just sitting in the car, and the Adrian police pulled up.
Okay, so when the police pulled up, did they ask you to get out of the car?
They asked me my name. I told them a different name, and they asked me to get out the car, and I took off running.
So you gave them a fake name?
Yeah, I told them my name was somebody else. They knew who I was, and I took off running.
Okay, and so you took off running, and they told you to stop?
Yes.
Okay, and you failed to do so. And they were wearing uniforms?
Yes, ma'am.
And you knew they were the Adrian Police Department police officers?
Yes, ma'am.
Okay, and on this one, do you know Officer William White?
I don't know who he is personally, no.
Okay, and what about Randy Spence?
I don't know him personally.
Okay, and would you agree they were but would you agree that they were two of them that were present that day?
Yes, ma'am.
Okay, all right, Mr. Bayonetto, are you satisfied?
Yes, Your Honor.
Has the court complied with MCR 6.302 B, C, and D? Mr. Murphy,
Yes, Your Honor.
Mr. Bayonetto?
It has, Your Honor, yes.
All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel, other than the Cobbs, to no more than 10 months in Lenawee County Jail. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation, and I'm going to set this matter for sentencing on February 23rd at 8:15 in the morning. So, Mr. Madison, someone from the probation department is going to come to the jail and they're going to meet with you.
Okay.
I'll give you a packet to fill out. You can fill that out.
Yes,
And when you do, be truthful about your background, especially be truthful about your addiction issues, because we can provide services to help you.
Okay.
And then about the offense that occurred, they'll prepare a pre-sentence report. We will provide that to Mr. Murphy in advance. Mr. Murphy will meet with you in advance to review that pre-sentence report. Now, do you want to appear in person or do you want to appear via Zoom?
Does it matter?
It's up to you. Doesn't matter to me, but it's up to you.
I'll do in person.
You want to do virtual? Okay. You said virtual, right?
I said in person.
Oh, I'm sorry. All right, so we will schedule that in person. And all right, so you're all set. And how long have you been in jail now?
With the time that I got, I've been in almost 90 days.
Okay. All right. So we will see you back then. All right, Mr. Madison. Thank you.
Thank you.
Thank you, Mr. Madison. Have a good day.
You too, sir, Ms. Bayonetto.
Yep, thank you. All right, so all of these. All right, and that's John Glazier. So we need to let Mr. Glazier know. All right, so I got Mr. Leach. Mr. Fleming, what are you here for?
I am on Chisler, Judge.
Okay. All right, do you want to meet with Mr. Fleming too, Mr. Leach?
We just spoke. He jumped on the call with the other attorney.
Okay, okay, all right. So
We've got a resolution.
Oh, we do? Okay. So this is in the matter of the people of the state of Michigan versus Aaron Eugene Schisler. And I have Chris Fleming and Isaac Sneed and Alexander Bayonetto appearing on behalf of the people. Kind of feel bad for Mr. Leach. There's too many prosecutors, and Mr. Leach appearing on behalf of Mr. Schisler. This matter is set for jury trial on January 23rd. I do show a prior plea offer, but Mr. Leach, what is the current plea offer in this file?
After discussions with Mr. Fleming.
Hold on 1 sec. Hold on, Mr. Leach. Something's happening with our VIQ machine.
You're back on. You're fine.
Okay, now you can go. Go ahead.
After discussions, many discussions with Mr. Fleming regarding this matter, we were prepared to proceed with trial. However, we've been able to resolve this matter with a misdemeanor plea, no contest plea to brandishing a firearm, Your Honor.
Okay, so there's going to be an added count for misdemeanor brandishing a firearm. And what's the maximum penalty for brandishing a firearm?
I believe it's 93 days, Your Honor.
93 days. All right. Is that a correct recitation of the plea, Mr. Fleming, Mr. Bayonetto, and Mr. Sneed?
Judge, it looks like brandishing firearm in public is going to fall under a 90-day. That's MCL 750.234E.
Yes, ma'am.
Okay. So, Mr. Leach, I have no objection to proceeding today without an amended information. The prosecutor's office should file it by the end of the day. Do you have any objection proceeding without that amended information?
No, ma'am. We can proceed. Thank you.
Mr. Schisler, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. And you are Aaron Eugene Schisler, correct?
Yes, Your Honor.
All right, you can put your hand down. So you've heard the statement of your attorney and the prosecuting attorney. Is it your intention today, it was a guilty or no contest? Guilty.
Okay.
No contest.
Oh, is it your intention today to plead no contest to an, right? No contest?
Yes.
Okay, somebody
No
spoke
contest,
over
Your
me, okay. And I didn't hear it. So is it your intention today to plead no contest to an added count for brandishing a firearm?
Yes,
Are you satisfied with your attorney and the advice that he has given you?
absolutely, yes.
All right, and you understand the maximum penalty for this offense could be up to 90 days in jail?
Yes, I do.
Is there a fine, Mr. Fleming?
It's and or $100 fine on that, but there could be court costs and whatnot as well.
Yeah, and then there's a fine attached to that statute. Do you understand that as well?
Yes.
There's also, Judge, there's also mandatory weapon forfeiture. I'm not sure we were able to seize the weapon, but there is mandatory forfeiture.
You guys do have the weapon.
Okay.
For 2 years now.
So do you understand that as well, Mr. Schizler?
Yes, Your Honor.
Okay, now, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any possible sentence with the court. Is that correct, Mr. Leach?
Yes, Your Honor.
Mr. Fleming?
That's correct, Judge.
And Mr. Schizler, is that correct as far as you're aware?
Yes, Your Honor.
If a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury, and in fact, you're scheduled for jury trial. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Schizler?
Yes, I do, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
Do you have a concealed pistol license?
Yes, I do, Your Honor.
Okay, and what would potentially be the impact of this conviction, Mr. Leach?
He's going to have a suspension period of a CPL, and he's aware of that. We've discussed it, Your Honor.
Okay, good. All right. So, Mr. Schizler, your answer to this will be not guilty or no contest. Do you understand that? My next question.
Yes, Your Honor.
All right. So how do you wish to plead to the charge that on or about December 28th of 2021 in the village of Clinton in the county of Lenawee, that you did commit the offense of brandishing a firearm?
No contest.
Okay. Has anyone made any threats or promises to you to induce you to plead no contest to this charge?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Leach?
No, Your Honor.
Mr. Fleming?
No, Judge.
Mr. Schizler, has your attorney promised you any particular sentence or estimated what your sentence will be?
No, Your Honor.
Is it your own choice to plead no contest?
Yes, Your Honor.
Right, and who will be placing the factual basis on the record?
I could be happy to assist with that, Your Honor.
Okay, why don't you go ahead?
I would.
Or Mr.
You would review a police report, Your Honor.
No, I don't have that, but Mr. Fleming, will you stipulate to the use? I don't get police reports because I don't, but
I will.
Mr. Fleming, do you stipulate to the use of the police report?
I will so stipulate, Judge.
All right, and can I have the date and police report number first, Mr. Leach?
Sorry, I got to pull that up.
or Mr. Fleming.
One moment, Your Honor, I'm pulling it up. Excuse me.
Here, I'll tell you what, let me, I can take care of this here. I'm reading from Clinton Police Department Report 21002551 that indicates that on or about December 28th, 2021, in the village of Clinton, County of Lenawee, State of Michigan, that the defendant and a people by the name of Sarah Ashby and Ricardo Rodriguez, they were involved in some sort of road rage incident. When they reached Clinton, the other two parties to that pulled into, I believe it was a coffee shop area parking lot alongside the defendant, at which time the defendant brandished a pistol. And that was at a public location. I believe that would satisfy the facts to count for, Judge.
I agree. That was factual basis.
That's probably Big B then too. All right.
Yeah.
Based on the facts, because that's the only coffee shop there. So based on the facts placed on the record and from the information contained in the stipulated to police report, the court finds beyond a reasonable doubt that on or about December 28th of 2021, in the village of Clinton in the county of Lenawee, that the defendant did commit the offense of brandishing a firearm by brandishing a firearm in a public place in the village of Clinton. And therefore, the court does accept the no contest plea. So this is a 90-day misdemeanor. Mr. Fleming.
I know that it's possible that the other two parties would wish to speak, Judge. So I would think it might be prudent to set up.
That's what I was going to ask. All right. So Mr. Leach, are you available for sentencing? Mr. Schizler, let me first ask, do you have any objection to appearing via Zoom for sentencing, or do you want to appear in person?
Zoom would be fine.
Mr. Schizler, your attorney's no objection to Zoom. Do you object to Zoom, or you want to be in person?
No objection to Zoom, Your Honor.
Because you live like Mount Blanc or Grand Blanc, right?
Yeah, by
Yes,
Plea.
Your Honor.
Okay. All right. And okay, so Mr. Leach, are you available February 23rd of 24 at 8:15 in the morning?
February 23rd is a Friday, Your Honor, correct?
Oh, no, yeah, February 23rd is a Friday at 8:15. Yep.
Yes, ma'am. That'll work fine. Thank you.
Okay, so I'm going to set this for sentencing on 2/23 at 8:15 in the morning via Zoom. So, Mr. Schizler, I'm going to go off live stream here in a minute, and I'm going to give you the contact information for our district court probation department, because they will prepare the pre-sentence report. And when you meet with them, I want you to be truthful with them about your background, the events that occurred. They'll prepare a report, and my office submits it to your attorney, and your attorney will review that with you before the day of sentencing.